Dear friends, here is the latest concerning my case, my fake case, and everything else in a nutshell. 1. As expected, the lower regional court in Hanover rejected my motion for a preliminary judgment to 1. Immediately set me free, and 2. Immediately stop the fake criminal proceeding against me without even looking at the facts of the case. Unconstitutional and criminal political persecution and abduction under the guise of fake criminal charges. All this took her, because she didn't even look at the facts, half a page of writing. We expected this, and now that they've shown their hand, we know that they do not have the cards, as a famous U.S. president frequently says when he means to say that he's dealing with incompetence. Just to give you a taste of what a more detailed account will look like when we publish our appeal against this ruling, she made her ruling without a hearing, and this cannot be overemphasized, without even mentioning one of the facts of the case, stating that we had not made our case with respect to the urgency of the motion. That's what it takes. If you want a preliminary injunction, you need to plead urgency. Why not? Because this is her saying this, because I had already stayed in prison for now more than 2 years and 8 months. So, which means they could keep me in here for another couple of years. We have completed the appeal and will publish it immediately. 2, here's good news. Well, the other is also good news. With respect to the almost complete shutdown of my communication rights, with which the Göttingen DA's office and Schindler had ordered this prison to impose on me, the higher district court in Braunschweig, Brunswick, ruled on June 2nd that this is illegal and that those who have a problem with my statements must pursue a different route. For example, if they believe that they have a case against me for defamation, to charge me with a crime. That, however, they will not do, as in a defamation case, truth is an absolute defense, and since they want to keep a lid on the truth, as it would expose their lies, they will not do anything. At this point, pretty much anything they would do will only make matters worse, as whatever they want to do must now happen before the eyes and ears of a worldwide attentive public that understands full well that we are indeed, all of us, in this together. Anyone could be next, after all. This means, of course, that I can now do interviews again, including live interviews. The only thing I need to stay away from is language that might amount to a crime. That's easy enough. After all, I'm a lawyer. I know how to get a message across. 3, a couple of months ago, 1 or 2 of the controlled opposition people who have infiltrated our side of the fence published a couple of hit pieces against me, consisting, as usual, exclusively of lies. One of the lies said that I had never really practiced law either in Germany or in the U.S. Well, I don't think I need to prove that I did practice law in Germany. All we need to do is listen to some of the witnesses who were heard in the fake criminal case against me, including Tobias Weissenborn and Katrin Behn, who were just 2 of the 17 attorneys working for me in my firm and testified to that. But there are dozens of TV interviews I did concerning cases against Deutsche Bank, but also on a couple of pro bono cases I did representing survivors of ritual abuse, including ritual child abuse. With respect to my U.S. legal work, we are now publishing a so-called amicus curiae brief, which I wrote and filed in a class action case against Deutsche Bank in 2017. I did this as a friend of the court. That's what amicus curiae means. To alert the court of the fact that Deutsche Bank regularly act intentionally when they commit a tort. Now, if that case against Deutsche Bank suddenly becomes a case of intentional infliction of harm instead of just negligence, then, as I point out in that brief, the court or jury has the right to think about punitive damages on top of actual damages. In that particular case, which was then pending before a Southern California court, the so-called amount in controversy, which means the amount of actual money damages the parties were fighting over, was $85 billion US. Add punitives to this, and you will immediately understand that this could have easily wiped out Deutsche Bank altogether. Well, a couple of weeks after filing this brief, I attended Deutsche Bank's annual shareholder meeting in Frankfurt and gave a short speech in front of some 4,000 or 5,000 shareholders, plus the entire board of directors of Deutsche Bank, explaining what kind of problem Deutsche Bank had to solve, or rather, what kind of Damocles sword was hovering over DB. Everyone went silent, and the board of directors pretended not to even have heard what I'd said. But another couple of weeks later, it's a small world, I ran into an aide to one of the directors who told me that all the DB employees' chins dropped when I gave them the good news. And just a little later, DB settled the case for an undisclosed amount of money. However, considering that the amount in controversy was $85 billion, it cannot really have been cheap. And by the way, I worked on that case pro bono too. Stay tuned. There's more to come shortly.